Good morning, this is your Kelso Report for Thursday, April 12th, and I'm your host, Clark Kelso. Today we have cases under the Americans with Disabilities Act, a parole ruling, and an insurance law case. We'll begin with the Americans with Disabilities Act in the Ninth Circuit. The plaintiff was a nurse in a neonatal intensive care unit, and she sought an accommodation from her employer hospital that would have allowed her an unspecified number of unplanned absences from her job. In essence, she wanted to opt out of the hospital's attendance policy, which sanctioned 5 unplanned absences of unlimited duration, as well as other permitted absences. And she used the Americans with Disabilities Act as the basis for her claim of exemption. The district court granted summary judgment in favor of the hospital, concluding that regular attendance is an essential function of a neonatal nursing position at the hospital, and the plaintiff was therefore not entitled to any accommodation under the ADA. The Ninth Circuit affirmed. A plaintiff establishes a prima facie case under the ADA by showing, first, she's disabled, second, she is qualified and able to perform the essential functions of the job with reasonable accommodation, and third, she suffered an adverse employment action because of her disability. The hospital in this case agreed that plaintiff was disabled and that she suffered an adverse employment action because of her disability. She was terminated. But the Ninth Circuit agreed with the district court that she was not able to perform the essential functions of the job, and that her request for an exemption from the attendance policy was unreasonable. As the court explained, the plaintiff's approach would have eviscerated any attendance policy, leaving the hospital with a potential for unlimited absences in its neonatal intensive care unit, which would have been an unacceptable way of managing that unit. So the Ninth Circuit affirmed summary judgment for the defendant. You have to show up at work, in short. Next, a parole case, California Court of Appeal. The Board of Parole Hearings found that the defendant qualified as a mentally disordered offender pursuant to Penal Code Section 2962 and conditioned her parole on the receipt of mental health treatment from the State Department of Mental Health in one of their upstate hospitals. She challenged the finding in the Superior Court, but it agreed with the board. On appeal, she argued there was insufficient evidence to support the trial court's finding because the prosecution relied on inadmissible hearsay in the guise of expert opinion testimony, and that testimony in some respects exceeded the scope of the expert witness's expertise. The Fourth District affirmed. Although the appellate court agreed that some of the expert witness's testimony was incompetent hearsay, and that some of her testimony exceeded the scope, the court nevertheless concluded that substantial evidence supported the board's and the trial court's conclusion, primarily because the substance of the expert opinion testimony was also found in a written probation report that had been admitted into evidence without objection by defense counsel. You can't just object to the hearsay evidence from the witness orally and simply let the written report come in without objection and hope to survive on appeal. Finally, an insurance law case. 2 insurance companies, Axis Surplus Insurance and Glencoe, provided general liability insurance in favor of Pacifica Point. Pacifica was sued in a construction defect action and tendered claims to both Axis and Glencoe. Axis agreed to defend, subject to a reservation of rights. Glencoe declined the tender, but monitored the suit and asked Pacifica to inform it once it satisfied the self-insured retention, the SIR, under the Glencoe policy. Pacifica and Axis paid a total of $1 million to settle the construction defect suit. Although Glencoe refused to participate in the settlement, it approved of Pacifica contributing its SIR of $250,000 as part of the settlement, which Pacifica did. After settling the construction defect suit, Axis sued Glencoe for declaratory relief and equitable contribution to recover at least a portion of the $750,000 it paid in settlement. The trial court found that there was a possibility of coverage as to Glencoe and allocated a 60-40 split of Axis's settlement payment to the advantage of Axis. Glencoe appealed, claiming the court committed reversible error in finding Axis proved a potential for coverage under the Glencoe policy, and that the court was required to allocate on an equal shares basis instead of employing its equitable discretion to reach a 60-40 split. In Axis Surplus Insurance Company versus Glencoe, the 4th District affirmed the trial court's judgment. The evidence on possibility of coverage was frankly overwhelming, and the 4th District held as a matter of law that the trial court had discretion to allocate either on an equal shares basis or by applying its discretion in light of applicable equitable factors, which is exactly what the trial court did. So judgment against Glencoe was affirmed. That's it for today's Kelso Report. Have a great day in the law.